Discrimination Act. What I want to now go over is Mass Equal Pay Act. Next slide, please. So this act was effective back in July 2018. It's been in place. I frankly haven't seen as many claims as I thought I would under the statute, but it does apply to all employers in Massachusetts. Next slide. So the act, generally speaking, there's four kind of buckets. The act provides 6 bases where you can provide variable pay. It restricts what employers can ask about an applicant's pay history. It makes it unlawful for an employer to prohibit employees from discussing wages, either their own or other employees' wages, with one exception. And then it provides an affirmative defense to the employer if you've conducted a pay audit within a requisite period of time. Next act. So basically what the act prohibits is that an employer cannot discriminate on the basis of gender in the payment of wages, or pay a person salary or wage at a rate less than rates paid to employees of a different gender. The key issues here are what are wages and comparable work. If there is an unlawful wage differential, the employer cannot reduce the wages of an employee to comply with the act. So you can't bring down the wages, the high paid person, to bring them to the low paid person and say, oh, guess what? Now there's no discrimination. Next slide. So wages are defined broadly. They are defined as all forms of remuneration for employment. That includes wages, salaries, bonuses, commissions, health insurance, and other fringe benefits. So you would have to compare the whole package as between the genders. Next slide. Comparable work is defined as work that requires substantially similar skill, effort, responsibility. It's performed under similar working conditions. There are some areas where employers can account for differentials, like reasonable shift, differentials, physical surroundings, and hazards. A job title or job description is not going to determine whether a job is comparable. They're going to look at the facts and as to the skill, effort, and responsibility and working conditions. And substantially similar is not defined in the act. So it's going to be fact-based and doing a comparison between jobs. Next slide. So I mentioned there are ways under the act where you can differentiate and pay between the genders. And the 6 bases are when it's based on a seniority system that's in place, a merit system, a system measuring quantity or quality of production, sales, or revenue. It can be differentiate based on education, training, or experience that's related to a specific job. And geographic location of job performance is another differential. And travel, if travel is a regular and necessary condition of the job. Next slide. So what's the analysis to do? The analysis first, are the jobs comparable? You look at the skill, effort, responsibility, and working conditions as between the two jobs and make a determination. Is the pay equality, is there pay equality between men and women? So that's a comparison of salaries and including wages, benefits, fringe benefits. Is there a pay differential between genders? And essentially, is it based on any one of those 6 factors? And you are limited to one of those 6 factors. That's the only thing that the statute recognizes as a basis for differential in pay. Next slide. So what happens if you don't comply with the act? An employer is liable for the amount of unpaid wages. That would be the difference between whether you paid a female more than the male or male more than the female, plus an equal amount as liquidated damages, plus reasonable attorney's fees and costs. The employee can file their claim directly in court. Unlike with discrimination claims, they don't have to go to the MCAD first. And unlike wage claims, they don't have to go to the Attorney General first. An agreement by the employee to work for less is not a defense. The employee's previous compensation history is also not a defense. And interestingly, and of significance is there's a 3-year statute of limitations So the employee can bring a claim anytime within 3 years after there's been a violation, and a violation occurs every time wages are paid. So the ability to file these claims, continues to roll along as time passes with employees being paid unfairly as between genders. Next slide. So under the Act, what are the unlawful employment practices? In a nutshell, you cannot prohibit employees from discussing their own or other employees' compensation. You cannot seek compensation history from a prospective employee, and you cannot require that a prospective employee prior compensation history meet certain criteria. What an employer may do is confirm prior compensation if the prospective employee voluntarily discloses their compensation, or after you make an offer to the employee with the compensation amount, and that's been negotiated and made to a prospect. You can then determine and ask to check on what their compensation had previously been. Next slide. So here's the bonus that's given to employers is you get an affirmative defense if you undertake and complete a self-evaluation of pay practices within the previous 3 years before a suit is filed by the employee. And you have to demonstrate reasonable progress towards eliminating wage differentials based on gender for comparable work. So you get a complete defense to the claim if this self-evaluation was done in good faith and reasonable detail and scope. The evaluation has reasonable detail and scope. And of course, you meet the two elements I mentioned up above. It's a partial defense if you can't demonstrate the evaluation was reasonable in detail and scope. You have to still meet the other criteria. And what you do get as a partial defense is you're not liable for that liquidated damage payment, which equals the amount of the difference in wages. Evidence of a self-evaluation or that you've taken remedial steps to eliminate pay inequality is not admissible as evidence of a violation. There are certain time restrictions to that, but we don't have time to get into all those details.